All right, Dr. McDonough versus City of Homestead.
Good morning, Your Honor. Dr. McDonough.
Morning. How are you?
I'm just fine.
McDonough. Okay, I always pronounce McDonough. Habit.
You got it right.
All right. All right. This is what I'm going to do, gentlemen. I'm going to listen to your argument. I've read your motions. I've read your response. Then I'm going to take a little advice. Okay, so you'll know.
Okay.
Your Honor, you broke up. I couldn't hear.
Okay, I've read the motions. What I'm going to do is I've read your motions and your responses. I'm going to listen to your argument, and then I'm going to take you under advice.
Okay.
So okay? Go ahead, Doctor.
Your Honor, if it pleases the court at the outset, I want to note that I've submitted a verified motion with competent evidence that I've attached thereto. To date, the city's only provided unsworn statements of counsel, which do not constitute evidence. That's State v. Walters, 12 Southern 3rd, 298 at 303 3rd DCA 2009. The motion to disqualify is not for all matters in this case, Your Honor, but only as to the trial or any hearing where Zeskind may be reasonably called as a witness. And this would not affect his ability to assist in other pre- or post-trial matters. The city, through Zeskind, objects to the motion, arguing they're allowed to select their counsel of their choosing. Generally, I would agree, Your Honor. However, Mr. Mandel has been the lead counsel in this case. Mr. Zeskind is a material witness who did not start acting as lead counsel until I began moving to depose him. And it appears he's doing such only to stymie my discovery. The city has at least 7 attorneys billing in my pro se cases. The city essentially alleges it will be prejudiced if it can only use 6 attorneys at will against a pro se litigant in a public records case. Clearly, Mr. Zeskind being a witness will not prejudice the city from having proper representation of their choosing. So, the first argument I want to go into, which is not really an argument, they bring into all their pleadings here, is collateral estoppel. With collateral estoppel, the Florida courts hold that collateral estoppel, also known as issue preclusion, applies where 1, the identical issues were presented in a prior proceeding, 2, there was a full and fair opportunity to litigate the issues in the prior proceeding, 3, the issues in the prior litigation were a critical and necessary part of the prior determination, 4, the parties in the 2 proceedings were identical, and 5, the issues were actually litigated in a prior proceeding. This is Pierce v. Sandler, 219, Southern 3rd, 961 at 965, 3rd DCA 2017. Your Honor, while we were litigating the first lawsuit over Request A, which is in case number 16012412, the city argued that there were only 5 responsive records and that all 5 records were exempt. Further, it was determined at the hearing in that case that additional records that were argued to be responsive therein, i.e. 2 invoices and an email, were produced in response to a subsequent broader request, i.e. Request 2. Your Honor, it's clear the issues at bar are not identical. 1. When the city responded to Request 1, the request at bar, it again alleged only 5 records to be responsive. However, this time the exemptions upheld by the 3rd DCA in the first case had expired. And this time the city produced the first 3 records, claimed an exemption for the 4th record, and stated they didn't think I wanted the 5th record, and did not provide that. 2. Others have filed requests identical to Request A and received records which were never produced to me in either Request 1 or Request A. 3. I submitted a follow-up clarification to the city broadening Request 1 to be as broad or broader than Request 2, yet still those additional records were not provided in response to my clarified Request 1. And City and Zeskind wholly ignored this fact that the request has been modified. These issues have not been previously presented or litigated, and the only element of the doctrine of collateral estoppel met by the city is that the parties are identical. Zeskind knows this, and his arguments otherwise just respectfully only highlight his lack of candor. Moving to the crux of the city's argument, Zeskind alleges that I primarily relied on a strained interpretation of a letter and cherry-picked excerpts from a hearing transcript in Request A. Your Honor, first, this letter is not simply concerning revisions to an appeal brief as averred by Mr. Zeskind. Zeskind admits in the letter to knowing that the withholding of financial records is being improper and recommending that issue not be fought, quote, before we ever even had the hearing, end quote. Your Honor, little can be applied here in this letter when put into context other than Zeskind knowingly and premeditatedly misleading the court in the other litigation. That Zeskind offers no further explanation or defense to this allegation of mine, I believe is also telling. Your Honor, the letter and its background is relevant and likely dispositive to issues herein. The desire to probe it, like other questions intended to be asked, are reasonably calculated to lead to discovery of admissible evidence. Further, the intended line of questioning is not protected by attorney-client privilege, and to any extent it is, Zeskind can claim attorney-client privilege, granted said attorney-client privilege is not pierced at our next motion. Second, while Mr. Zeskind argues the transcript's excerpts are cherry-picked and out of context, he fails to provide any context which would show him not acting as a material witness. Zeskind argued before the court that he was the designee. Had Mr. Zeskind only provided legal advice to the custodian of records or her designee, his arguments would hold water, Your Honor. However, once he acted as the designee, he was effectively acting as an agent of the city processing my request. And as such, he's the material witness. There's simply no one else with personal knowledge who I can ask about why Zeskind did what he did while acting as an agent processing my records request. Also, allegations in my motion were completely ignored by Zeskind. One of those is Zeskind has failed to refute the allegation that he was the attorney who actually reviewed the records responsive to request 1. 2, Zeskind has not responded to my allegation that he knowingly provided false statements to the courts, claiming I had stated that I intended to write a book to teach people how to harass government entities with public records requests and win the subsequent lawsuits. It is this false claim which Mr. Zeskind made in writing, upon which the false allegation that I filed for an improper purpose is based, Your Honor. Mr. Zeskind is the only witness, and I should have a right to the discovery, including deposition, to be able to defend from such false claims and the liability that would attach. Your Honor, Mr. Zeskind is the only material witness with personal knowledge, and there's no other means for me to obtain the information than to take his deposition. The information sought is relevant and not protected by attorney-client privilege, and without this information, I cannot properly prepare my case nor defend from Mr. Zeskind's false accusations. Therefore, in my motion, I've met the elements necessary to depose Mr. Zeskind and have met them under Eller, ITO, Steve Doring Company, LLC versus Pandolfo, 167, Southern 3rd, 495 at 496, 3rd DCA, 215, and Your Honor, I believe the motion should be granted.
Thank you. All right, Homestead.
Good morning, Your Honor. Sam Zeskind, the voice of Rhoda Helfman for the defendant, City of Homestead. My partner, Matthew Mandel, is on as well. I don't think there's any secret about what's going on here. Despite what Dr. McDonough just presented, it's evident on the face of his motion that this is purely a litigation tactic. He's seeking to pierce attorney-client privilege and take my deposition, not about anything that relates to the public records request that is the subject of this complaint. Dr. McDonough barely even mentioned that. What he's looking to do is take my deposition about things that occurred in the litigation that I represented the city on that concluded 4 years ago, Your Honor. That litigation concluded when the 3rd DCA entered a ruling finding in favor of the city on all issues and against Dr. McDonough on all issues. He has the email he's referring to because after that case concluded, he did a public records request. That email is a public record. It was produced. It doesn't make me a material witness in this case. It does not reveal in any way, and nothing that I've said or done on behalf of the city or that anyone in my firm has done on behalf of the city has been adverse to the city,
hold on. Does the doctor meet the requirements to disqualify you as the attorney for the city of Homestead? That's
No,
really the issue right here. On the others are peripheral stuff. The reasons of what his intentions are really irrelevant. What I don't know is does he meet the threshold?
No, Your Honor. I will disagree just momentarily that his intentions are irrelevant because the case law makes clear that it can't be done as a litigation tactic, which is what's happening. But in terms of the elements, that are required to be met, no, he hasn't met them. He has not demonstrated in any way that I am a material witness in this case. And not only does he have to demonstrate that I'm a material witness, he also has to demonstrate and prove through evidence, through an evidentiary hearing, Your Honor, that the testimony that he seeks to elicit from me would be adverse to the city. He's not met either of those requirements. He hasn't shown, the reason why we're talking about the last litigation is because that's what he's seeking to depose me about. And that's what he wants my testimony on. That's where he thinks I'm a material witness. He's not demonstrated in any way that I'm a material witness in the instant litigation where he made a verbatim public records request, but years later. And he's not demonstrated at all that my testimony would be adverse. It would not be adverse, but he hasn't had an evidentiary hearing to establish that it would be, which is necessary for Your Honor to disqualify me. So those are the two key elements. If opposing party wants to disqualify counsel based on the taking of their deposition or seeking their testimony at trial, it's laid out pretty clearly in Furman versus Furman, which is 233rd Southern 3rd, 1280. It's a 2018 Southern District case. That both of those things need to occur, that I need to be a material witness, which I'm not, and that my testimony elicited through an evidentiary hearing would need to be adverse, and he hasn't shown that. It won't be. So no, he has not satisfied the elements necessary to disqualify me. He is, however, correct that disqualification would only relate to trial and not working on the matter. But either way, it's not appropriate. And despite his contentions, there are not 6 or 7 attorneys working for the city on this particular case. He has 3 other pending public records lawsuits against the city, 2 other pending lawsuits in the Southern District of Florida against the city and several of its current and former employees. We have other attorneys in our firm that work on those matters. He's sued in excess of 5 or 7 of our attorneys and our firm directly in other public records litigation, because in our capacities as city attorney, we are agents of the city. But there's no justification or grounds here to disqualify me as counsel for the city at trial.
Thank you. Doctor, you get the last word.
Your Honor, what's really important here is in his response and his arguments here, Mr. Zeskind has not refuted that he reviewed the records subject to request 1. In the prior litigation, I can prove that Mr. Zeskind made many false claims and an improper interpretation of the request therein. I'm not relitigating that request, Your Honor. I agree, I refiled a verbatim request. However, I then modified that request to make it broader. This is not the same facts. And I'm trying to prevent Mr. Zeskind from bringing his false allegations in the first case into this case and tainting this case with those, Your Honor.
Okay, thank you. I'm going to take it under advisement. I'll send you an order. Gentlemen, is there a co-reporter present?
Yeah, yes, there is.
I just want to make sure. Okay. Anything? Thank you very much, and we'll see you soon.
Thank you very much, Your Honor. You have a blessed weekend, sir.
Have a good day.
Thank you, Your Honor.